Then when we're dealing with criminal matters, now we're dealing with the people, the entire populace of the state. And all criminal charges are brought in the name of and by the authority of the people of the state of Illinois. So it's the people against an individual. The individual being the defendant or the defendants in the case who are charged with having violated the criminal laws of the state of Illinois. And be it civil or criminal, the judge presides over the presentation of the evidence in that case, and where there is no jury, then the judge makes a decision as to who is right. Okay. In a civil case, one of the parties will prevail. In a criminal case, one of the parties will prevail. It'll either be guilty if the people's case prevails, not guilty if they're unable to prove the guilt of the defendant beyond a reasonable doubt.
Okay, I guess that would also encompass the responsibility of a judge that a judge has to the juror or the person that is being tried.
No, let's spend a little time and talk about the difference between a case where the judge acts both as the fact finder and as the giver of the law, and a case where there is a jury. In the jury case and in a criminal case, every defendant has an absolute constitutional right to have his case heard by a jury of his peers. His peers has been come to be meaning a jury selected from the geographical area where the defendant lives, or where the crime takes place, the alleged crime takes place. And once that jury is selected, generally it's 12 people. Now, in order to ensure always that there are 12 people hearing the case, generally you will find juries are selected of 14 or more. The extra jurors over and above 12 being considered alternate jurors to take care of eventualities where jurors become sick or die or for whatever reason are unable to continue in their duties as a jurors through the conclusion of a case. Then the alternate juror steps in and takes that absent juror's place. But the jury is the fact-finding body in the case that they're called upon to hear. They make a determination as to the facts of the case, and they make that determination by listening to the people testify and to such other non-testimonial evidence as is presented in the case. There's other kinds of evidence other than oral testimony, you see. There may be a gun. There may be a book, there may be an object, there may be a pencil, there may be a pen that has some significance in the evidentiary context of the case. That's evidence just as is oral testimony, and all of that evidence is put in the courtroom in the presence of the jury, and the jury makes a determination as to what they find the facts to be. Now, they apply to the facts as they determine what the facts are, the law, and that's where the judge comes in. The judge is the lawgiver. The judge tells the jury what the law is in the case, and they take the law which is given to them by the court in its instructions and applies those instructions or the law to the facts, and thereupon they arrive at a verdict.
Were you going to say something, Judge? No. Oh, okay. You mentioned a point whereas people that are being tried are supposed to be tried by people of their peers. Okay. What I gather you mean as far as social, economic, racial background. When you say peers, or maybe you want to define that for us. Well,
the way it has been defined legally by our various courts is that a person's peers are people who are selected from the geographical area where the person resides. And the geographical area in Chicago has become to mean Cook County. So jurors are selected from the body of people who reside in Cook County, and that has become to mean the peers, regardless of their racial background or ethnic background.
Frederick Douglass observed 100 years ago that when a black person takes arms against people that are doing injustice against them, in the case he cited was white people, then it was the consensus that things like that should be taken care of. Justice should be served immediately. And my question would be, do you still see that happening now? You know, whereas if the shoe was on the other foot, or was it if it was turned around, it wouldn't be quite that way. And this was 100 years ago. This was stated now.
I think that he meant 100 years ago in talking about immediate justice was that if arms were lifted against you and you had arms and you used those arms, that was that justice during that period of time. To an extent, that's still the same thing that's going on now as we observe through the carnage that's going on in our cities, in our large metropolitan areas these days, in the shootings and the killings that are going on. But have we become more civilized? I doubt it. I think that in many instances we're less civilized. And I'm talking about the general population.
Now, what do you feel about that, Judge Pincham?
I am a student of Frederick Douglass, and I'm trying to recollect the context in which he made the statement. And I'm trying to analyze the context in which you're asking the question as a derivative of the statement. Perhaps it is my convoluted or distorted thinking. I perceived you asking basically about, well, why don't you rephrase it?
He was saying that he said that a century ago that white America perceives a black who raises his or her arm in self-defense, and I did not add, in self-defense, that is considered as a grave threat and that it should be punished, justifiably punished.
Oh, well, now, when you added the phrase in self-defense, you put a different
tone on
spin entirely upon it, because self-defense has always been a basic, fundamental defense to any person being charged with a crime. So if one acts in defense of their own person or in defense of the person of their family or in defense of another in situations where they believe that such actions is necessary in order to prevent death or great bodily harm to them or someone else, then lethal force is legally permissible. That's self-defense. But I don't think that that's the context that Frederick Douglass was using that phrase back there 100 years ago, because 100 years ago the situation was such that a black wasn't considered a citizen, so therefore he wasn't considered and shouldn't have been considered under those circumstances, because he wasn't a citizen, as being susceptible to the constitutional prescription that allowed a white person to use self-defense in defense of his own life. So in that context, back in those days, blacks weren't considered citizens, and if they lifted arms, even if it was in support of their own lives, and their own lives were in danger, they were not given in the courts of law that right that were given to the white citizens of that day.